Welcome to another episode of Workplace Matters, coming to you from the heavenly Broward County Bar Association in Fort Lauderdale, Florida, with my co-host Diana Castrillon.
Hello, everyone.
And we have a very, very special guest for our episode today. Diana, you want to introduce him? Because I can go on forever speaking about the praises of our guest today.
Well, it's funny you say that, only because I feel like Richard Chait is a person who does not need to be introduced to the world of workers' compensation. If you don't know Richard Chait, what's wrong with you? But call me and I'll tell you. There's a lot of great stories to be told about Richard. But, rather than spending the short amount of time that we all have together talking about, who he is, you're going to hear from him in just a few minutes, and you're going to figure out very quickly the impact that he has to our practice of workers' compensation. But, we thought it would be kind of cute, and I think it's a great idea to tell you a little bit about how the three of us came to sit at this table and talk to everyone today. And what's very funny about that is I heard that there's history that exists between the two of you that goes way, way back. So Richard, tell us a little bit about where that connection started between you and Henry.
First of all, good afternoon, everybody. In the spirit of the Talking Heads and the song, "Once in a Lifetime," same as it ever was. Same as it ever was. Here we are, and we're discussing workers' compensation. But essentially, it really isn't same as it ever was, because I would like to represent to the audience that we're in a stronger place than we've ever been, notwithstanding the fact that we are under a perceived attack yet again. That's the same as it ever was. In terms of my history with Henry, what most people that are practitioners don't realize is when Henry was in law school and I was in the first partnership that I had in my career, Henry was my law clerk. And there's a few stories that Henry likes to share with me. I know that I conducted myself with Henry the way that I've conducted myself throughout my whole career. I believe mentorship is incredibly important. I don't think that should be an elective class. I think that should be a required class. I think that it's a healthy way about, especially in our small, tight niche community of workers' compensation, because there's a lot to be said about past history and seeing how we've evolved so that we can determine that there's a healthy model and we can sustain that model. So some would joke, if they want to be tongue-in-cheek, that I'm responsible for Henry being in workers' compensation.
It's true.
I would joke that I just brought him to his first work comp convention, and he decided he wanted to build a career out of it.
Well, honestly, a lot of stories, but truly, the mentorship, the friendship throughout the years has only made myself as a practitioner better, I believe. How do you two know each other?
We just met, right?
Not even.
No.
Not even. You all are so blessed to have Diana, and I understand that she's going to be the president of the Broward County Bar, the first workers' compensation attorney who's the president of the Broward County Bar, and you all are blessed to have her. From my perspective, Diana's always been a leader on our team, and not only that, but she's just an incredible human that I am proud to say we can call each other friends. She served on the Florida Workers Advocates Board of Directors. She served on the Workers' Compensation section of the Florida Bar's Executive Council. Now she's basically serving on the Broward Bar Association. She's incredibly involved with the Workers' Compensation Bench and Bar of Broward County. Well, what's the common ingredient there? She serves, she gives back, she's a leader. And you know what? Leaders find leaders. People that are good people have good people radar, and this is a good person to my left here.
You're very sweet. I paid him to say this. So
How much?
it was like $10, but it was very well served. But in truth, we do go way back, and I have a tremendous amount of respect for everything that Richard does. And this was just kind of tongue-in-cheek to get started with our talk today, but really the reason that we're so excited, honestly, to have been able to get Richard to sneak away from the edge of the commencement of the legislative session of 2025, which is apparently bound to be quite a doozy for workers' compensation practitioners, as it tends to be. And the only reason we haven't seen a lot more action is in no short part due to the guy sitting here to my right, because really having leaders there who understand workers' compensation and who have access to the legislature and are able to talk about our plight as workers' compensation practitioners. So this is not a claimant's bar thing. And that's why we wanted to bring Richard here today, because, obviously I'm a claimant's attorney. Henry's a defense attorney.
Always will be.
Always will be, unfortunately. Teasing. But in truth, we are able to give a diverse perspective. And I love that Richard is really able to truly physically sit in the middle and also explain how much the workers' compensation world and what's happening in our legislative process impacts both sides, claimants as well as the insurance world and the employer world.
And I would also suggest it affects the judges of compensation claims. It affects the Office of Insurance Regulation. It affects DOA in large part. It affects employers. The one thing I learned when I started my career, because I did start and practice for the first four years doing defense work, is that when you're representing the employer carrier, you have two different clients, and a lot of times those are divergent interests, and you have to be very cognizant of that.
That's
so
true.
I guess what I would just say in a nutshell to summarize Diana's point is it's really important that you have someone that has credibility, that has passion, that is honest, that knows the system, and can walk the fine line and thread the needle, okay? And essentially that's what I do. But in addition to that, perhaps one of the most important job responsibilities that I have at this stage of my career is to build relationships with people who are worthy, with people who are instrumental to our well-being in terms of protecting and preserving the entire workers' compensation system and enhancing when and only when appropriate.
So just not to ask an incredibly open-ended question, what's going on with the legislature? What's the chatter? Because I know what I've heard. Tell me what you've heard.
Well, unfortunately, there are special interest groups, okay? And the biggest mistake that anyone could make is to blame the legislature, okay? Because our relationship on behalf of the workers' comp industry, on behalf of the workers' compensation section of the Florida Bar, of which I'm a past chair, I'm still the longest-standing member of the Executive Council and their legislative chair. And I don't say that with any degree of ego. I say that with a degree of importance because it's very, very critical that we have continuity, that members of legislative leadership are conditioned to, if it's a workers' compensation issue, you're dealing with the same person, and there was never a rule book, there was never an owner's manual or Cliff Notes, okay? This has all essentially just been an evolving process that has been a result of everybody's support and the need for everyone to continue to support and double down. And this is a perfect example. So notwithstanding the fact that our Florida workers' compensation system, since the last significant reform, which was a 2003 reform, the rates have gone down a collective 78%.
Wow.
That's impactful.
Okay.
78% they've gone down, and yet still we remain under attack.
Correct. And so legislative leadership, the Speaker of the House of Representatives, the Speaker designate of the House of Representatives, the important impactful chairs, and then the Senate President, the purported next Senate President-elect, okay, other very valuable members that are chairs, they get that. But that doesn't mean that there's not going to be an outlier in both the House and in the Senate that is driven by a special interest, and that is exactly what we're dealing with right now. There is a special interest group that evolved out of the state of Texas, and for purposes of simplicity, this is essentially being proposed as an opt-out from the traditional workers' compensation system that is so healthy, it's enjoyed a 78% cumulative reduction in insurance rates since the last time we needed major significant reform in 2003. And we've done a lot of good things collectively since then, okay? We've enhanced the salary structure for judges of compensation claims so that we can recruit better judges, since judges are having to give up their practices to be able to take on that appointment, okay? We've essentially taken off the handcuffs of the judges with respect to the EMA process, the expert medical advisor, which, based on that 2003 reform, essentially handcuffed our judges and said that basically they were mandated to rule in the way that the EMA, someone who saw the injured worker one time, basically determined what the outcome was supposed to be. Well, it is now may appoint an EMA as opposed to shall appoint an EMA.
And it's so funny how much of an impact one word in a statute can have,
One
right?
word.
Removing the word reasonable sent our entire world into an uproar.
Correct.
Adding or exchanging the word may for shall makes another huge impact in our
Well,
legislative
and the
process.
sky hasn't fallen, and cases are still streamlining and moving.
Well, that's
And-
the one thing that I think that the '03 changes and the rules that came after that really have made a difference in our practice. We can now, if these cases are being litigated, move these cases quickly from petition to adjudication, and we're there. There's no, gone are their days, with rare exception, where you'll have a claim that gets filed in 25 and we're not seeing the inside of the courtroom until 27, 28. I remember practicing in the 90s and the early 2000s, getting to final hearing was a big deal because it took forever. But now with the way the system is now.
So the last thing we did positively, which really baffles my mind, that a very respectful member of the Florida House of Representatives and a very respectful member of the Florida Senate would even consider running this type of a proposal. But last year, we were asked to weigh in on getting the physicians who practice in the workers' compensation system their first significant increase in a fee schedule since that 2003 reform. And we did it successfully. And I was asked to testify in both chambers. I testified 3 times in the Senate, 3 times in the House, met with the governor's office, and we were able to pass this unanimously, with the intent being that now we have a system that is marketable to doctors to want to get into it, okay? So that not only can we potentially be bringing in new doctors and higher caliber doctors, but we're also going to have a pool of more doctors so that when insurance companies have to reserve cases or when agreements are finally reached that the injured worker is going to see a specialist, there's not additional delay where the sand continues to run through the hourglass.
And
Rich,
that's
I'm
actually a really
confused.
that's a big point, because there are places in the state that it's just hard to find a doctor to accept workers' compensation patients. And I understand that the financial part of it, and I understand that sometimes all the paperwork's a little onerous for the doctors, and we're still heavy on forms and workers' compensation, but that helps both claimant and defense, because not only does it take the delay out of it, which could lead to longer periods of disability, maybe not the highest quality of care, but it really, really just eviscerates that issue. The other part I didn't like about it is now we got to pay doctors a little bit more for deposition.
Well, you're not paying for it. Your clients
You had a
are.
question.
But but here's my question, because honestly, as you're describing this to me, and we have a defense attorney, a person who represents employers and carriers, agreeing with you, and myself, all going, wait a minute, you've just described an incredibly healthy system in the state of Florida.
Yes, ma'am.
You've described a system where employers are being able to get their employees back into the workforce quickly. You're describing an expedited and effective system in our state where we're able to bring better judges to our courts, where we're able to have more quality doctors to treat our injured workers, and all of the parties who are interested in the outcome are being positively impacted over the course of the last 4 years, 3 years, 6 years, 10 years, 7 years. So why are we having
Well, that's an excellent
this
segue.
conversation?
Yeah.
And you know
What's
what?
the
Why
deal?
are we having it?
What's the deal?
Because there are special interest groups that look at the state of Florida as fertile ground. Okay, the state of Florida certainly conducts itself as a progressive state. Okay, and they've decided, and it may be because basically 2 sessions ago there was massive tort reform. I am proud to tell anyone that's affiliated with the workers' comp system, it was the first time in my 37-year career that workers' compensation was not annexed to tort reform, and there was a reason for it. The reason is sitting to my right, sitting to my left, and everyone who has supported this cause and essentially engaged in this model. But for this Texas opt-out proposal to even be considered right now,
It's crazy.
it's an insult to the Florida legislature and all of the good quality legislative policy that was essentially governed, passed, and approved and implemented into law. I mean, the paint isn't even dry on the wall. And now essentially we've got the potential risk of throwing the baby out with the bathwater. And it's insulting. It's insulting to anybody who has put skin in the game. And I am pledging to basically spend this session speaking to as many people as possible, because even if this concept that may or may not still become a bill, because it is in bill drafting, although it's very possible by the time you all are seeing this podcast that we're already game on. And I have every reason to believe it's game on, okay? When House members have limited bill slots and one of the members has essentially assigned one of those slots to this concept, I don't think they're gonna just walk away. But let's say hypothetically, or God willing, that we do get through this session, well, this isn't gonna go away, okay? They're gonna keep rattling the cage, which means we need to stay ahead of it. We need to be proactive. We cannot allow complacency. We cannot allow for the slippery slope of, well, but we've known Chait for a long time, and we've respected opinions coming from the leadership team, and we've heard that there's reform, but then nothing ever passes, okay? Well, I'm here to tell you, ladies and gentlemen, that what goes on behind the curtain and the reason why nothing passes is so substantial, and it requires everybody's collective effort and attention.
It's just fine. It's a little offensive, right? When the taxpayers ask us to do, stakeholders to come together and create policy that works for everyone. And we've done that in the workers' compensation field with our current model. And yet there's still forces out there that want to shake things up. For what reason? I have no idea.
I'll ask you this, Rich, while we have you here, because obviously this is what you do, all right? And the fact that this hasn't been more at the forefront over the last few years is in no short part to the fact that you're in there talking to these folks every single day, reminding them of the importance of our system, the importance of everything that we have in place right now, and the amazing effective system that we've created in our state. But let's talk about what opt-out means, because we've heard that term. That's a hot term, right? But what does that mean in a short version?
It's a little gray because the bill is still being bottled up in bill drafting. Okay, so
what does it mean in Texas? What would it mean if they followed the Texas
well, what
model?
it means in Texas is that if you are an injured worker in Texas, it is virtually impossible for you to secure adequate legal counsel. Okay, I've also spoken to other prominent members of the defense bar who they have multi-state practices. Okay, their practices for their clients that they represent, their employers or their carriers or self-insureds in Texas, it's not viable. Okay, and my additional concern is that this essentially removes the judges, it removes the doctors, it requires litigation to be handled in federal court through an ERISA claim, okay? This is violative of the Florida Constitution. It is a direct insult and will result in a challenge to access to court, equal protection, and due process. Texas took this on the road. Texas brought this to Oklahoma, okay? Oklahoma bought it hook, line, and sinker until it was deemed unconstitutional,
Right,
okay?
that was in 2016, I believe.
Correct. Now, the problem is, and what we've learned with, say, the Marvin Castellanos case, is it takes from 2009 to 2016
Right.
to work through that process and have law declared unconstitutional, okay? Now, back in 2009, we didn't have the platform, the standing, or the reputation that we have diligently earned and have right now. There is now a model in place that gives us a seat at the table that is respected. We never had that before. This is all of our collective investments, okay? This isn't just a model that goes through the legislative session of 9 weeks, okay? This has become essentially a 24/7, 52-week-a-year model where if we're not in Tallahassee, we're traveling around the state, meeting with legislators, being proactive. The only disappointing thing is now we're back to having to play defense.
Well, I'll tell you what, as workers' compensation practitioners, whether you're representing injured workers or you're representing employers and carriers, whether you're a judge, whether you're a mediator, or any other stakeholder in the world of workers' compensation in the state of Florida, you are going to be impacted by what is being proposed right now.
Absolutely.
So we have a unique opportunity and moment in time where we're meeting with Richard Chait on the eve of the commencement of legislative session. And he's been so gracious as to offer to come back and meet with us again at the conclusion of session.
Right.
And let us know how our conversation today, what that has turned into, and what we experienced during legislative session and where we stand at that point. But the message that I think we're trying to make clear to our entire industry is that our industry is under attack. The concern in the past had been attorneys' fees are under attack and how that impacted other sectors of our practice as a claimant's attorney. But this is extraordinarily different, and I can't make that point clear enough, is to let everyone know that this is not a claimant's bar problem, a defense bar problem. This is a systemic problem that affects the workers' compensation system as a whole and every single player in that system.
It even has a greater impact, in my opinion. I mean, it impacts the claims professionals that administer these claims, the risk professionals that have spent a lifetime working to ensure that their employees have access to adequate care under the workers' compensation system. This is a game changer.
This is a game changer. So if you are involved in organizations, if you are not, then reach out to us, reach out to your peers, find out how you can help save the system, save injured workers, save our careers, save the profession, but more importantly, save an extremely healthy system that exists in the state of Florida that has facilitated benefits to injured workers, that has allowed employers to provide their employees those things that they need to continue to move forward in their practices, that has allowed for insurance companies to benefit from huge rate decreases or significant rate decreases over the course of the last several years. Everybody is doing really great in this system right now. So the only reason that anybody will be considering doing anything to this system should be cause for alarm, should be making you question that. And like we said, this is part one of what we hope will be at least part two, but potentially a multi-part conversation, because this is something that's important and we need to discuss as an industry. And with that, Rich, if you have any closing words to say to
it'll be my pleasure to come back. Look, I've been blessed throughout my career. I have more professional colleagues, friends than I could ever have dreamed of. But I'm personally writing a new chapter right now. I'm building relationships with very prominent members of the Florida House of Representatives, the Florida Senate, instrumental lobbying members that in the past just looked at us as we were taboo. And it's amazing when you just interject a personal approach and you're consistent. And oh, by the way, you know what the message is? The message is, here's our ask. Do nothing. We don't want anything other than to continue to protect and preserve the system. Do nothing. And it's hopefully going to be the ask that's going to carry the day. I'll just close with this, that this isn't going away. And if it's not this, it's something else. This is our proverbial wake-up call, okay? You don't see panic in my eyes, but you do see diligence and persistence. And right now, we have earned and been blessed with the opportunity to have a seat at a very impactful table. But there are hundreds of other interest groups that are also looking to get a seat at the table. Well, as you can see, as I look to my right and I look to my left, oftentimes the table is limited to certain attendees. So with that, I look forward to coming back. Thank you for having me. And please, folks, stay vigilant.
Thank you. Thank you for coming.
Thank you very much. We look forward to seeing you for part 2 of this and for additional episodes of Workplace Matters from the Broward County Bar's Workers' Compensation Section. See you next time.
See you next time.